The Honourable Damien O'Connor.
Thank you, Mr Speaker. And again, I'll take a short call just to once again state that Labor will support this piece of legislation. And it's not very often in this House anyone can stand up and say that perhaps we've had a visionary and timely piece of legislation that hasn't been in some way retrospective. But indeed, the Civil Defence Emergency Management Amendment Act 2016 was indeed very timely, and what we're doing, of course, is just making some adjustments so that it can be implemented in a shorter time frame than was originally proposed in the bill that was literally just passed in this House on the 10th of November. And so it's kind of sensible, and some of the discussions have been had, but like everything, improvements can be made, and that's what we're talking about here. It's hard to have arguments with anything in here, Mr Speaker, but I can't help in going through the particular provisions ask a few questions as to why, and I think point out, as has been said in the House before, the human realities and commercial realities that don't always exist when we assume that people would check their buildings after such a large quake. We would assume that people would ensure they're safe after a quake. In fact, that doesn't always occur. There are a whole lot of, I guess, in some cases desperate situations, in some cases presumptive situations where they might think the building's new and it should stand up to an earthquake. But as we've seen with the Statistics New Zealand building and the Defence New Zealand building, they are indeed very, very new, but have ended up being quite unsafe. Yet we can walk around Wellington here and see some very, very old buildings that at this point anyway, we assume they are safe. And what we do need to know is that they have all been properly assessed. And as has been pointed out here, owners can appeal if an assessment's done, because as we've seen from the Christchurch disaster, engineers are not all the same. And we need to ensure that there's an ability to check their capability, I guess, in their assessment themselves. But well, Clause 7 did raise an interesting issue for me, Mr Speaker, because it said, during a state of emergency or transitional period, of course, a direction can be given, of course, to prevent risk of injury or safety of life or safety of property. It doesn't add any risk to health, but we would assume that risk to health is another one of those things that should be assessed. And doing that, of course, in state of emergencies or transitional periods would beg the question, what about other times? And indeed, there are a lot of other times where risk to health and indeed risk of injury, which is often the same thing, are not assessed, because this government refuses to implement a warrant of fitness on many, many houses and buildings through this country that are quite frankly unhealthy to live in. Is that unsafe? I don't know. I guess people listening could make that judgment themselves. I think unsafe is unhealthy, and I'd like the government to pick up what they're doing here in this piece of legislation, and later on over the next 6 to 9 months that they might be in government before we get in there, Mr Speaker, to actually implement a warrant of fitness regime for all tenancy arrangements throughout New Zealand. I think that would be real progress. Mr Speaker, I'd just like to say, once again, that Labor will be supporting the legislation. I think, the technical things that should have always been included in the original legislation, a question of why not, is that it's an offence to withhold information or giving false or misleading information. We would just assume that that would be in place already. But anyway, a tidy up and a hurry up, which is what we're doing for the main piece of civil defence emergency management legislation, Mr Speaker, is something that Labor supports, because we want to help the people who have been affected by this earthquake. Kia ora.
Chris Bishop.